All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. This is the time for argument in our civil number 17-550. Matthew Madonna et al. Versus State of Arizona. Steve Yarborough and others as interveners and appellees. Each side will have 20 minutes in which to argue its position. The appellants may reserve a portion of that time for rebuttal argument. Counsel, you'll have to keep track of that time for yourself. We've read the briefs in conference this case. We're familiar with the facts and issues presented. Would each of you, as you begin your argument, identify yourself and the party or parties you represent? Counsel for appellants may proceed.
Good morning, and may it please the Court. Rupali Desai and Andy Gayona from Coppersmith Brockelman on behalf of plaintiffs' appellants. And with us here in the Court are three of my clients, the Animal Defense League of Arizona, represented by Stephanie Nichols-Young, Sandy Barr, and the Arizona Advocacy Network, represented by Joel Edmond.
But you will be arguing for appellants.
Yes, Your Honor. From statehood, when the people reserved to themselves the power to legislate, Arizona courts have held that the citizen initiative must be subject to a lenient standard, a substantial compliance standard. In 2017, frustrated by the will of the voters and the co-equal power of the citizens to legislate, the legislature passed House Bill 2244 to overrule the substantial compliance standard and to implement a strict compliance standard which directly curtails the right of the citizen initiative.
How?
As a starting...
I don't understand how strict compliance with procedural requirements curtails the right.
Your Honor,
if the Supreme Court had held that loose compliance is required or partial compliance is required, wouldn't the legislature have the ability to tighten that up?
In Turley, the court set forth the standard for a direct violation of Article 4 or for a constitutional provision, and that is if there is an unreasonable hindrance and the law does not supplement, then it is a violation. But this court need not reach that issue. We believe, and we've asserted a claim for an Article 4 violation, and we do believe that it curtails the right. But that is not the main claim that my clients have brought before this court. The claim that is squarely before this court is the Article 3 separation of powers claim, which does not require that you decide whether or not HB 2244 directly curtails the initiative right. Also, there was plenty of evidence that was actually adopted in the findings of fact by the judge in this case to find that the right of initiative would be curtailed if HB 2244 goes into effect, which it has, and in fact, we now know that that law is curtailing the right of initiative.
How do we know that?
As late as this Saturday, when one of the two of the clients that I represent have been involved in an initiative effort, at the time they testified in the trial court, they talked about the trophy ban hunting initiative that they were involved in.
Are these the facts that you filed yesterday in the notice of facts not in the record?
Yes, Your Honor.
All right. Ms. Desai, what authority do you have to file such a pleading?
We believe that those facts, which weren't available to the court at the trial court level.
Answer my question. What authority do you have that you could file such a pleading?
So State v. Valenzuela talks about.
Where can you find it in the Arizona Rules of Civil Appellate Procedure?
Well, there is no rule of appellate procedure that talks about supplementing the record with facts that didn't exist at the time. In fact.
Well, hold on a second. Aren't we, as an appellate court, aren't we confined to reviewing those matters only contained in the record?
Your Honor, these facts, no. The answer is no.
We're not?
In a situation like this, and the court has the authority to expand the record given the unusual need or extraordinary circumstances, and we just this morning filed a response to the state's motion to strike where we cite several cases, State v. Valenzuela being one of them, Landy versus Federal Deposit Insurance Corporation, which is a Third Circuit case.
But we're to take these facts that have not been tested by cross-examination or anything like that. We're supposed to take them whole cloth.
Your Honor, we wanted to make sure that the court had the most up-to-date information with respect to testimony that was provided by our clients in the trial court. But you need not even reach those, you need not consider those facts, frankly, to hold in my client's favor. Those.
And why did you do it?
Because both, it corrects information that was provided below in the trial court. My clients testified
This information in this document that you filed yesterday was provided to the trial court below?
No, Your Honor. My clients testified at the trial court level that they were involved in an initiative to ban trophy hunting in the state. These facts, which are now known to us that did not exist at the time.
Which weren't known to Judge Stevens.
That's correct, Your Honor. But they are correcting information about their involvement in an initiative that is no longer. But I would like to explain to this court why the actual facts of injury established by the notice that we filed with this court or the evidence that was provided at the trial court, you don't need that evidence of injury to find that the claims in this case are ripe.
The fact that you submitted them would seem to suggest that any concerns about ripeness have traction, and that perhaps you can remedy a ripeness issue by going back to the trial court with a different claim. But this isn't the first court in which you present such facts.
With all due respect, Your Honor, I disagree. We have 4 alternative grounds to show that the claims in this case are both ripe and are adequate for redress by this court. And if, with permission from the court, I would like to go through those 4 separate grounds for why this case is ripe. So, first of all, the clients that I represent in this case are not just ordinary citizens. They are not people who are just off the street saying, my right to the initiative in some abstract way is going to be affected by HB 2244. Each and every one of the plaintiffs in this case are individuals or organizations that have historically been engaged in the initiative process. They testified at court that they were actually in the planning stages for the initiative.
But that goes to standing, right? Not ripeness.
Well, ripeness is a variation of standing. And the courts in Arizona have held that to establish ripeness, you need to be able to have some sort of palpable injury that is not based on some contingency that may or may not occur in the future. And
Ms. Barr testified in front of Judge Stevens that there was a potential initiative that would limit trophy hunting. There was a potential initiative. That doesn't seem to be concrete to me, counsel.
what Ms. Barr testified to.
Well, I'm more concerned about what Judge Stevens found.
Well, so let me just point you to the testimony from Ms. Barr that I think is relevant here. At pages 38 and 40 of the day 1 transcript, Ms. Barr talks about being involved in a contemplated initiative in which she is actually working for the drafting and connected with raising money with respect to collecting signatures for that initiative.
Isn't contemplated the operative word there, counsel? Contemplated? Isn't that speculative? We don't know if that's going to, at least Judge Stevens didn't know if that was going to go forward or not at the time that this evidence was taken.
For purposes of establishing ripeness in a case of such great constitutional magnitude, which this case is, what this court should understand is that the initiative process is not a finite, there's not one finite moment at which an initiative happens. And in fact, this is one of the problems with the trial court's ruling in this case, which is Judge Stevens holds that there is no actual initiative that's been filed. The state defendants go on in their papers to say, well, that's not exactly all that's needed for this case to be ripe. In fact, they need to file an initiative, they need to collect signatures, they need to actually turn in those signatures, and then they need to be sued for strict compliance in order for this case to be ripe. That cannot be the test for ripeness. And in fact, the 10th Circuit, in a case very similar to this one, addressed this very issue with respect to standing and ripeness. That case, Initiative and Referendum Institute versus Walker, talks about when a claim becomes ripe for review when specifically the right to initiative is implicated. In that case, the 10th Circuit said that plaintiffs may bring suits for prospective relief where they can demonstrate a credible threat of prosecution or other consequences flowing from the statute's enforcement. The injury is not the defeat of a particular initiative or even the greater difficulty faced by groups like the plaintiffs who decide to mount an initiative campaign, but the dampening effect of the congressional act on the initiative.
And that's a 10th Circuit case?
That's correct, Your Honor, and the citation is 450 F. 3rd 1082. And the 10th Circuit explained, and I think this is key, by definition, the injury is inchoate, because speech is chilled, and in this case, we don't have a First Amendment claim, but the conduct relating to initiative is chilled if you know that you are going to have this higher standard that is going to become more expensive for you to do your initiative. You need to collect more signatures. That testimony in the trial court is unrebutted, that there needs to be a greater cushion of signatures that are gathered to qualify the initiative.
I think it's clear why there's dissatisfaction in some quarters with the law, but the question has to come back to the separation of powers issue that you identified, right? So let me change to the merits here for a moment and point out that in ARS 13104, the legislature said, and I quote, "The general rule that a penal statute is to be strictly construed does not apply to this title." Okay, they loosened the standard of construction. And I'm not even going to get into a long dissertation on why I think Justice Scalia is right about strict construction, but let me simply ask you if that statute is unconstitutional because it prescribes a mode of construction.
Your Honor, I think the key, and I'm not familiar with that statute, but the key to determining whether a particular standard in a statute violates the separation of powers is whether or not that standard has come down through an interpretation of the Constitution. So I will give you an example that is similar. There is no debate that a content-based restriction, a law that imposes a content-based restriction is a First Amendment claim that has to be reviewed under a strict scrutiny standard. If Congress wanted to enact a statute that says that needs to be reviewed under a rational basis standard, that would not be okay.
Clearly, but strict scrutiny, and which evaluates whether a law is constitutional, is far different from the concept of strict compliance. And again, I'm focusing my analysis here not on strict construction, because an unambiguous statute doesn't need to be construed, but the concept of strict compliance, which is also contained in this law you're challenging. Strict compliance has nothing to do with strict scrutiny.
The strict scrutiny analogy is precisely on point, and it's not the only one. So we cite Dickerson in our papers. That case also makes clear that the question that is really the crux of this is whether or not the standard, the rule of law that has been pronounced by the courts is one that is based on their interpretation of the Constitution. To agree with the state defendants in this case, this court would have to agree that the long list of cases in Arizona, starting from Whitman in 1942 all the way to Feldmeyer that came down in 2005, over the course of 60 years, over and over and over again, our Arizona Supreme Court has interpreted Article 4 of the Constitution to require initiatives to be subject to substantial compliance, a lenient standard. Their having interpreted the Constitution to require that is not mere common law that can be superseded by legislation, as the state defendants argue.
So would you read that line of cases as saying that no matter what the governing statute is, only substantial compliance is required as a matter of constitutional right?
The constitutional right to the initiative requires a lenient application, and the courts have called it substantial compliance. And
well, that was my initial question,
well,
right? We could say lenient, substantial, strict. All those words, that's quite a spectrum.
Well, there's a difference between strict and lenient. In fact, they're polar opposites. And so I think in Dickerson, the Supreme Court said, if Congress wants to go enact laws that are not exactly the Miranda rights, if they want to enact a statute that says these are the kinds of information you need to give to somebody in custody to make them aware that they have a right against self-incrimination, they can do that. But it has to be consistent with the law that we announced in Miranda. It can't be something exactly the opposite, which is what happened in Dickerson. They passed a law that said you can actually admit statements made by somebody in custody without having given them the Miranda warnings if it was a voluntary, and then it sets forth this entirely different test for what constitutes voluntary, which is entirely based on what law enforcement's impression of that was. The Supreme Court said no. And like the case in Dickerson, I would submit to this court that stare decisis requires that this court uphold the Arizona Supreme Court's long list of cases holding that a lenient standard or substantial compliance is required by the Constitution with respect to the citizen's right to an initiative. So, so I think that that's a very important point to establish first, that this is a constitutional right, that the legislature cannot simply supersede judicial decisions. That is a violation of Article 3 and the doctrine of separation of powers. But getting back to the ripeness question, which is the one that this case was wrongly decided on, it is not simply because of the constitutional right at issue that guarantees or gives my clients an opportunity to be before this court, but there are other grounds as well. There is the Declaratory Judgment Act, and I know that this court has decided two of the cases that we cite in our papers, Canyon del Rio v. City of Flagstaff and Kagi versus Northbrook Property. Both of those cases talk about when a justiciable controversy exists if there is an assertion of a right, status, or legal relation in which the plaintiff has a definite interest and a denial of it by the opposing party. We brought a declaratory judgment action in this case. We sought a declaration from the court that HB 2244 is unconstitutional. And Judge Stevens wrongly concluded that my client needed to suffer the very injury that we were seeking a declaration from the court that was unconstitutional. And both of those cases explain that you have a right to be before the court before an occurrence of injury, before an occurrence of breach. That's in Canyon del Rio. And in Kagi, this court opined that the Declaratory Judgment Act is interpreted liberally. So when there is a claim under the Uniform Declaratory Judgment Act, the case should be able to go forward. Those are standing and ripeness cases. Finally, with respect to the issue of ripeness, this court has the ability in its discretion to waive those requirements. There are prudential requirements. We believe we satisfy the prudential requirements because of the constitutional nature of the claims. We believe that the Declaratory Judgment Act gets us to where we need to be. We believe that the findings of fact that this court must defer to, and there are pages of findings in Judge Stevens' ruling explaining my client's position with respect to the injury they are already suffering from, increased cost.
If those are findings that she made, then why did she come to the conclusion that there had been no injuries sustained by your clients?
Well, Your Honor, and that is why we are here. We do not believe that the conclusion she reached is supported by the findings.
Well, I think the conclusions she reached were that they were kind of anticipated injuries, not injuries that they had actually sustained yet. And that goes back to Judge Swan's comment that begs the question of, if that had been satisfied, why this 11th hour, 59-minute pleading you filed yesterday that now shows or now contemplates and argues that you now have sustained an injury?
If this court were to decide that all of these findings of fact in Judge Stevens' ruling, which I believe if you read on their face clearly establish that there is injury, if the answer to that is that does not equal injury, then this is a catch-22 in which many, many initiative proponents will never be able to seek redress in this court because of the fact that HB 2244 makes it more expensive, requires more signatures, causes initiatives to fail before they even get filed, which is what happened in the case of my client Sandy Barr and Adla. Then there is never a ripe issue, and if they bring this claim after their initiative already fails, then there's an argument that it's moot. Either way, it's a problem, which is why in the context of the First Amendment and many other constitutional claims, the courts have held that a pre-enforcement challenge, and by the way, this is a facial challenge. This is not an as-applied challenge. We argued in the lower court we didn't need to have evidence. We didn't need to have depositions. This was a straight issue of law. It was a pure issue of law. It was a facial challenge, and on its face we can show that HB 2244.
So under no circumstances out there could this HB 22 be constitutional?
No, Your Honor. It is superseding judicial decision-making about the standard required for citizen initiatives. And if there aren't any other questions, I'd like to reserve the remaining time for rebuttal.
Thank you, counsel.
Good morning, and may it please the court. My name is Kara Carlson. I represent the Secretary of State, and I'm also going to be arguing on behalf of the other intervener appellees as well. The trial court properly dismissed this because plaintiffs lack standing and the claims were not ripe. Simply put, plaintiffs had not taken a single step. They hadn't filed paperwork for a serial number. They hadn't collected any initiative signatures. This is utterly insufficient to confer standing or for this court to reach the merits of the case because it wasn't ripe.
Although election cases happen on very quick timelines, right?
Election cases do happen on very...
So is the right moment to bring a substantive constitutional challenge to a law the moment when there are about 3 days to decide the case?
No, you're
tell us when the right moment is.
The right moment, we argue that the case would be ripe when there is a challenge to a set of petitions. And why that's the case is because you don't know if there's going to be a challenge. You might have sufficient signatures to not be overruled by strict compliance or substantial compliance. You might not be challenged, in which case the law doesn't have any impact on you. And this is important. Plaintiffs, and we agree with them, they have said that they will try their best to comply with the law. And in fact, they have to in order to meet the substantial compliance standard. So if they're already trying their best to comply with the law, then whether it's challenged under strict or substantial can't really impact their efforts until you reach the litigation stage, until they're actually challenged. Now, plaintiffs cite a number of First Amendment cases, but those cases all explicitly state that the standing requirements and the ripeness requirements are relaxed. And furthermore, the Walker case, that was also a First Amendment challenge. That was explicitly a First Amendment challenge. And the law in that challenge applied to initiatives that had already qualified for the ballot. So they knew that even if they go through everything that would be required to make it to the ballot and they were otherwise entitled to be on the ballot, they were still going to face this additional hurdle of meeting the 66% vote requirement. So that is very different here than the case where you're not entitled yet to be on the ballot, and the question is whether you're entitled to be on the ballot. And in Walker, the court ultimately found that even the 66% requirement was not sufficient to declare that law unconstitutional. That law was ultimately upheld. So it was a different standard. It was the First Amendment standard for ripeness, and they ultimately lost. And plaintiffs have not provided a good...
But I guess my question stands. When is the right time?
When there's a lawsuit challenging the petitions that have been submitted.
When there are just a few days to decide the entire question, the courts should take up not only the question of whether a petition is sufficient under whatever standard actually constitutionally applies, but also address the question, very fundamental question of the constitutionality of the law. Should do that all in a few days.
Yes, Your Honor, that's what courts are forced to do in election challenges all the time, and there are special...
Courts are all the time faced with the challenge of evaluating a certain petition or certain set of signatures for a candidate. They're not always asked to make sweeping constitutional rulings overnight. And the ripeness doctrine is prudential. Is there some reason that it's a really good idea to rush this decision?
We're not arguing that they should rush this decision, but just in 2016 in Graham versus Tambury, the state Supreme Court made a constitutional decision that the candidate signature requirements for the Libertarian candidate for U.S. Senate, there was a constitutional challenge there, and the court went through the process and did the constitutional analysis and was able to reach a conclusion, and he was ultimately, the law was upheld and Tambury was not granted access to the ballot. But that doesn't, that is what's required in order to analyze the merits of the case, whether there's an Article 3 or especially an Article 4 violation. You really have to reach the merits. You have to, the requirements for an Article 4 violation is whether it is unduly burdensome. You have to look at how that is impacting the plaintiffs. Second,
I guess would you agree with me that ripeness is a prudential doctrine and not a constitutional requirement?
Yes.
Not a statutory requirement.
Well, it is a prudential requirement that Arizona Supreme Court has said derives from the separation of powers argument. So in this case, they're essentially asking this court to ignore Article 3 as to standing so that they can reach the alleged Article 3 question. There are still rules for...
Well, we don't have an Article 3 standing requirement the way the federal system does.
Correct.
And so if it's prudential, what do you think is most prudent to do? I don't think that it's necessarily in any side's interest to say that compressing a major constitutional decision into a few days is a good idea. That doesn't tilt the playing field in favor of either side. In fact, it may work to the detriment of the defenders of the law, or defenders of the statute.
Prudentially, there are requirements as to when you are able to waive the standing and ripeness requirements, and plaintiffs just have not provided that here. They haven't given a reason why we should waive standing requirements, and they come asking for relief for an Article 3.
I think waive standing requirements might be too strong a statement of the position of the other side here. I don't think they're suggesting that there should be no standing requirements. I think they're suggesting that they've been met, and the question is, I hate to use the word, how strictly do you apply those requirements to determine when you should decide a case? Do you think I'm misperceiving the argument?
I think that because they're asking the court to review Judge Stevens' finding or ultimate conclusion, which was that the case was not right because there was no injury. I think that in their opening brief, in fact, one of their main points is that even if the Court of Appeals does not find that there is that this case is ripe, they could waive it under the prudential standards because it is merely a prudential standard. But a prudential standard does not mean no standard. It has to be significantly compelling, and these waiver standards are very, very limited for good reason. We don't want the court issuing advisory opinions on cases that might never come to be. If we're going to relax the requirements in this case, so much so that the finding is there's no injury to the plaintiffs at all, we are essentially asking this court for a comfort order for the plaintiffs that they can do something different than the law before anything has happened. And they're not alleging, unlike the other First Amendment cases that they're citing to support their position, they're not saying that we don't intend to comply with the law. Because they can't. In order to meet substantial compliance, they have to say we're going to try to comply with the law.
Would this be a closer case, Ms. Carlson, if the facts that Judge Stevens was presented with, that there had been an application for a petition of a serial number, that the Arizonans for Wildlife had made the comments that are reflected in the appellant's notice of facts, not in the record? Wouldn't that be a closer call for ripeness?
Yes, we do believe that that the reason they filed the notice of facts not in the record was essentially an admission that they didn't have standing or rightness at the time. The initiative, the filing for the serial number didn't occur until September 25th. The trial took place July 12th and 13th. And in fact, Judge Swan, you had asked about the brevity of the proceedings. Well, in this case, the initial complaint was filed in late April, and we had trial after discovery in July, and there was the final order by the court in August. So that's
not terribly brief. I guess my concern is with what happens if your proposed timeline or proposed application of these prudential standards were adopted in its fullness. Would you wind up effectively compressing very important constitutional questions into time where they might not receive adequate consideration?
You would end up compressing it, yes, but I don't think that means they wouldn't receive adequate consideration.
I appreciate your confidence, but sometimes it takes more than a day or two to resolve questions of this magnitude.
Yes, we understand that. If anything, there would be, as the plaintiffs asked for in this case, a preliminary order issued and further determination if the court truly believed that was what was required, if there just wasn't sufficient time. There are ways to address that if those facts do come before this court. But again, those facts never came before this court. No fact other than the initiative proponents were seriously considering running an initiative, and that they believed, the findings of fact repeatedly say, we believe it will cost more, we believe it will be harder, but we're going to try our very best to meet the standard. And that just doesn't, under any formulation of standing and rightness, just does not get you there. And to go to the merits argument, the Article 3 rule is in San Carlos that the courts will analyze the essential nature of the power exercised, the legislature's degree of control in exercising the power, the legislature's objective, and the practical consequences of the action. And here, in San Carlos, the legislature amended a law mid-litigation that would require certain stream adjudications to automatically be considered de minimis and removed entirely from the court's purview. And so one of the things that the court addressed was that if you have a stream that's producing, or a river that's producing 100,000 acre feet of water, the de minimis determination is very different than a stream or a trickle that's producing 2 acre feet of water. If you want to take an acre foot of water from both of those bodies of water, there will be a vast difference in the impact to the water rights implicated there. And because the legislature removed the court's authority to look at those facts, that was where the violation of Article 3 came in. This is not that case. HB 2244 does not remove the judge's authority to look at the facts of the case and apply those facts to the law. It simply says that this is, that strict compliance is required. And that is not foreign to our democratic process. The legislature is charged with making the laws, and they have plenary authority to regulate the initiative process so long as it's not unconstitutional. And we know that because we've got a whole list of statutes under Title 19 that provide certain requirements. And when the Constitution, when the drafters wanted the Constitution to say something specific, unlike the federal Constitution, there's a lot more detail. So, for example, the initiative and referendum requirements require the specific percentages of people to sign require the 4 months prior to the election. Like, there are very specific requirements. They could have put substantial compliance in those statutes, and we know that they knew about them because the 1939 statutes and the statutes before that all included that terminology, that substantial terminology. So it's not that this was lost on them, but they left it to the legislature. And Whitman specifically addressed, like Whitman, the court that was setting up the substantial compliance standards, specifically cited to the statute and said it is expressly required by the statute. And I think that that's important. This is not a court-made constitutional rule. The court looked at what the legislature required, and they applied that standard. And again, the court has to presume constitutionality where it can, and we believe that the is a strong argument here in favor of the presumption of constitutionality because a substantial compliance derives from a rule of the legislature. And furthermore, even though initiative and referenda in the Constitution, textually, the language is almost identical. The reason Western DevCorps carved out referenda for strict compliance and applied this different standard was they provided a rationale. They looked at a 1953 amendment to the statute that said that the legislature was concerned about, I believe the terminology was small pressure groups misusing and abusing the initiative process. And so the state Supreme Court found that even though we've said that, we're going to look at, review these under strict compliance or under substantial compliance, things have changed, and we're going to change at least referenda to strict compliance. And they actually, in that case, left the question open specifically whether or not that same change in the standard would apply to initiatives. And, that's further indication that this is not a constitutional rule that is set in stone. There is no right to have your initiatives reviewed under substantial compliance. You have a right to initiative that you can exercise, but you have to follow these procedural requirements. You have to meet the requirements in the Constitution. It's important for all branches of government that there are rules set forth, and under the Arizona Constitution, the people are considered part of the legislative body, but just like the legislature can't make rules without following the procedure that's required of them, the people can't legislate outside of the rules required by the statutes in the Constitution. Are there no more questions? Thank you, Your Honor.
Thank you, counsel.
Briefly, I'd like to just touch on a couple of points. It's simply disingenuous for the state to claim that there is no different result with a strict compliance and a substantial compliance standard. And the legislature would not have enacted 2244 if there was no result, if the result was not different.
Well, but I have to say, the cases you cite that talk about the right to a substantial compliance review are all construing statutes. I've seen that there's a strong public policy in favor of initiative, justifying a certain construction of a statute. In Cromco, the construction was of a statute, I have yet to see a case that says there is a constitutional right to loosely comply with a statute. And the legislature, it seems to me, has simply changed the rule, the underlying rule that the courts were interpreting. How do we get from there to the notion that there is a constitutional divide between the court's ability to interpret statutes and the legislative ability to enact them, that prohibits the latter but ensures the former?
Your Honor, all of the cases that talk about the strict compliance standard, or frankly, the substantial compliance standard in the referendum context, arise in the context of a particular petition challenge. So when you say they are talking about or referencing a particular statute, those courts are not saying this statute requires strict compliance or this statute requires substantial compliance.
Well, what they're saying is that the term legal sufficiency, and I'm just reading it straight from Cromco, the term legal sufficiency requires substantial, not necessarily technical compliance. That's how the courts have interpreted that language that the legislature used.
No, Your Honor. With all due respect, that is the standard that the court is interpreting is required by Article 4. There is no language in any of Title 16 or Title 19, which are, in Title 19 are the statutes that govern ballot measures, initiatives, and referendum. Now, since HB 2244 has been enacted, there is a provision that talks about strict compliance. But there has previously not been, the courts have not said this statute requires substantial compliance. What Whitman...
I just read you a quote from Cromco where it said that.
Cromco says...
Term legal sufficiency as used in Section 19122C, a statute, requires substantial, not technical compliance. That's not anything other than an interpretation of a statute. So when you say I'm wrong about that, if you've got another case that has a supervening principle, please cite it.
Well, I think Whitman and Feldmeyer talk about, and even Cromco talk about generally the requirements as to the form and manner in which citizens exercise their power of initiative should be liberally construed.
Should be is a lot different from constitutionally must be. I think, and there are cases going all the way back to early statehood that say, as a matter of policy, we think the courts should be very wary about imposing too many burdens. Understand that. But then again, that's a restriction that the courts placed on themselves as a matter of policy. That's much different than saying there's a constitutional right.
And I think that this court need not go any further than the purpose and findings statement in HB 2244 itself, where the legislature states its unconstitutional reason for doing this. They felt like the Voter Protection Act is too strong. It makes it too difficult for the legislature to reverse laws passed by the voters. And so they, instead of doing what they should have done, which is refer to the voters a constitutional amendment and try to convince voters at the ballot that the power imbalance is too great and they need to amend the Constitution, they simply overruled the judicial decisions that have existed in Arizona from the beginning of time and said initiatives must be governed by the strict compliance standard.
The statute doesn't purport to overrule the VPA.
It says in no uncertain terms, this is at our Appendix 54, the Voter Protection Act greatly impairs the ability of the legislature representing the will of the people to implement changes to or corrective measures for voter-approved initiatives.
That's an expression of discontent that doesn't find its way into the statutory language. Why should we read it?
Because it evidences the intent, the unconstitutional intent of the legislature to do a roundabout to circumvent the VPA by making initiatives more difficult. And
in terms of construction, we only go to outside the language if it's ambiguous. No one's made an argument it's ambiguous. So why do we go to the language you just cited to us?
Your Honor, the intent of the legislature to make initiatives more difficult goes directly to the constitutional violation.
The legislature consists of 90 people. And it usually can't act without the governor. How does that one document tell us anything about what that constitutional process intended? It tells us what some people intended, and I'm not even sure that that's relevant in any situation, because what we care about is what the legislature actually said and what the governor actually signed in a constitutional process. It makes me as nervous to talk about this as it does to talk about the intent of the electorate, which is highly varied. There are millions of people in this state cannot be said to have a collective intent, and I don't think that the legislature necessarily does either, which is why we avoid reference to such materials when we read statutes.
Your Honor, the case law, and I see that my time is up. I would like to make just one brief point. The state did not answer your question, a very important question in this case, about the right timing to bring this kind of claim.
Well, answer my first question and then get to that one, if you would.
Without looking at the intent of the legislature, we need only look at the referendum and initiative cases in this state. And we cite this in the papers below. We give the court, we gave Judge Stevens a chart that showed these are the referendum cases under a strict compliance standard. Almost all of them fail. It is why in the state of Arizona we have so fewer referendum than we do initiatives, because historically under the substantial compliance standard, it is easier, as it should be, for the citizens to directly legislate under a substantial compliance standard. So putting aside the intent of the legislature, we know that when you apply a strict compliance standard, it makes it more difficult for citizens to exercise their constitutional right to an initiative. And the case law bears that out. The question of timing is important because the state claims that the notice we filed is an admission that the claims were not ripe. We disagree. In fact, it proves the point that injury can, and in this case, did occur before a lawsuit challenging the petitions was ever filed, which is the narrow ripeness standard that the state believes that this court should adopt, that somehow you have to go through every single step of an initiative process and be sued at the end under strict compliance in order for your claims to become ripe. That can't possibly be the standard. At what point does the impairment to the constitutional right that HB 2244 imposes, as it did on my clients, could they bring a claim and it be ripe? We believe that this issue that we're talking about today is an issue of great importance. It's likely to recur under Arizona jurisprudence. That gives this court enough to find that there is sufficient standing and ripeness in this case. Thank you.
Thank you, counsel, for your arguments. We'll take the matter under advisement. We'll issue our decision in due course. Court's adjourned.